Hi, I'm Corey Nathan, and this is Talking Politics and Religion Without Killing Each Other. Your home for edifying, provocative, and fun conversations among high-profile public figures and regular folks like me. We talk about faith and politics and all kinds of topics that really matter in our culture. So if you're tired of all the screamers out there taking all the oxygen out of the room and you want to join us in taking some of that space back, you'll love talking politics and religion without killing each other. Thanks for spending some time with us. Enjoy today's show. Welcome, welcome, welcome. We are talking politics and religion without killing each other. I am your host, Corey Nathan, and so grateful to have a place to talk about faith and politics and big ideas in our culture with all kinds of interesting, accomplished folks of goodwill in good faith. And please be sure to support us at politicsandreligion.us. That's politicsandreligion.us. And without further ado, let's dive in. Today's guest, fresh off of his appearance on NBC News Now, is Danny Cevallos. Danny is a legal analyst for NBC and MSNBC and is the co-founder of the law firm Cevallos and Wong, LLP. He focuses his practice in the areas of state, federal, and territorial criminal defense and civil litigation. Danny also handles wrongful conviction and malicious prosecution cases. He's handled a number of high-profile cases in the federal, state, and territorial courts, ranging from white-collar criminal matters to first-degree murder cases. And you may have previously seen him as a legal analyst at CNN, HLN, and TruTV, and as a regular on shows such as Erin, Burnett, OutFront, and AC 360 with Anderson Cooper. But perhaps most impressive is Danny's distinction as a 7-time winner of a 10 out of 10 rating on Rate My Skype Room. So Danny, come on, I got to get some free advice here. How'd you pull off the whole room rater thing?
I'll be honest with you. I mean, really, and I hope he or she, because I think it's an anonymous anyway, the room rater Twitter handle rates everyone's Skype rooms, which was a brilliant idea during the pandemic. And I became obsessed with it, putting together a decent Skype room, which, by the way, is really difficult. I mean, you've got to get your lighting right. You've got to get your background right. And you know what I find now that I do Skype shots all the time for TV? It is really hard to find a place with some natural light and a nice background. And I see you've got some great bookshelves there behind you. You set everything up. But you know what? You've had 2 or 3 years to practice now. When this first started, nobody knew what they were doing. And, I was buying lights and cameras and everything. And so anyway, I take a lot of pride in my 10 out of 10 on Rate My Skype Room, the Twitter handle that just really, I think what he or she does is just watch TV, clip a picture, put it up, and gives it a 1 to 10. And I languished in the 7s and 8s for a long time before I got my first 10. And honestly, a lot of it was butt kissing. I was constantly, giving favorable remarks or comments on their posts. So, a little kissing up never hurts in my mind.
Awesome. That's awesome. Yeah. I had my first appearance on a TV hit. And my wife's first comment when she saw it was, "Oh, we got to do something about your lighting." Because usually it's just this, we see 60 seconds on, and usually it's the guests that we're highlighting on the stuff that we do on social, but this actual TV thing, I this one lousy plant I got behind me is on the death's door. I got to do something about that. But okay,
that's okay. You got a plant. That's the important thing.
Now I have a very, very serious question. There is another individual that every person in my home has a crush on, including me, my wife, me, Anderson Cooper. Is he as cool as
Anderson? Yeah, Anderson is a really, really terrific person to work with. I mean, really, all the folks at CNN were terrific. All the folks obviously at NBC and MSNBC are great too. But Anderson was really that was one of the first shows I ever did when I was in TV at CNN. And it was a thrill to be on with him. And, he couldn't be nicer. I mean, he's really, if you like Anderson on TV, you'd like the real guy, because he is just really a very friendly, very warm guy. And, he's in the middle of a show. I think if I had a show like Anderson's, I would be so stressed out. I would not even have time to talk to the guests, but he takes time to talk to everybody. He's very friendly. And if he sees you in the halls, he says hi. He's just really, I think you see what everyone sees, and what I saw is that he's just a delightful guy to be around.
That's encouraging, because sometimes you hear just the opposite. It's a persona that they have on TV, and so that's encouraging. I'll tell Miss Lisa, my lovely bride, that he's the real deal. So that's encouraging.
He is.
So I wanted to learn a little bit more about you and your background. You went to Michigan for undergrad, Notre Dame Law. Did you grow up in the upper Midwest, or is that just where you went to school? And
sort of. I mean, I'm a native Philadelphian. Parents got divorced, went out to live with dad, and then ended up in college out in the Midwest at Michigan because it was in state where my dad lived. And then from there, Notre Dame, because I got in. And that was, I was delighted to get into any of them. I didn't think I'd have a prayer at either of the schools. And so I went, and I ended up, a lot of my friends are now in school, working in the Chicago area. I have a lot of Midwest friends, even though I live out here in New York now. When you go to school at Michigan or any of the Big Ten schools, you're going to end up with a strong center of gravity near, Chicago or the Midwest. I say that, and in just the last few hours, I don't know if you follow sports. I don't really follow sports, but I was shocked to find that UCLA and USC have now joined the Big Ten, and you have Rutgers and Maryland. So the Big Ten isn't really a Midwesty kind of conference anymore. But the point is, when you live out and go to school out there that much, I have so many friends in a gravitational pool in the Midwest that it's I love to visit Chicago anytime I can.
Oh, that's great. Yeah, Michigan has a great. So you must have come after the Fab Five were playing ball there, right?
Immediately after, like the next year, that's where I graduated and went the very next year after they left. So I missed the two exciting years and got some very, very humdrum years after that. And I'll tell you this, again, I'm not a huge sports fan, but the year I left Michigan, the next year, 1997, our football team won the national championship. So do not have me at your school if you have any interest in doing well in sports.
That's awesome. I just thought you might be a glutton for all that cold weather between Michigan and Indiana for law school. But no, New York is a little better, I guess. So you live in the city there, or you have a nice house in the sun? Because you have a young family, right?
I do. And we live in an apartment in Manhattan. And this is the only discussion that parents of young children have when they live in Manhattan in an apartment, because that's pretty much, what there is here. Is, every single day is when are we moving out of the city? But, there's something about this city, be it our jobs or whatever the case may be, that keeps us here. And, who knows, we might end up raising the kids in the city. It has its own set of challenges, but it's got a lot of benefits in that you're close to everything. It's exciting. There are a lot of things for the kids to do, but you definitely get your steps in every day, because not a lot of driving. You end up doing a lot of walking.
Yeah. I was curious. I mean, with a young family, there's so much that you do running a firm, and all the cases, you're very hands-on, but you have all these media appearances. How do you manage it all?
I get asked that question a lot. And, fortunately, if you're really careful, running a law practice is something you can have a lot of control over. You can have a lot of control over court dates. You can control things like, when depositions go on. But other than being actually physically in court, especially now in the last few years that you can do TV hits from, if you have a stand and some lighting, you can do it from virtually anywhere. And let me tell you something. When I say anywhere, I have been in the craziest places and gotten an emergency call for TV and set up my stand, which I carry with me, and my lighting and everything else, and get it going and do the hit from anywhere, whether it be, in a parking lot. I got to tell you, I don't know if this is legal, and I guess I should know. I'm the lawyer. I once did a hit from the South Bend airport, sitting and waiting for my flight. I had my stand, I set it up, they needed me, and I did it. And, in retrospect, I don't know if that violated any FAA regulations, but I did it. No one said anything, and I got away with it.
It's interesting. I think if you were in Southern California, you'd have folks that were, whether they were security or part of the police, the sheriff's department, they're sniffing out for people shooting illegally. And part of the reason is that in LA County in particular, it's such a revenue generator for the county to make sure everybody's permitted. So there was a one time in particular that we were shooting this, little third. I was helping out our local church and shooting a little short film for them. And literally security came running out. You can't shoot here. You can't shoot, with our little handheld, nothing. But
sure. Yeah, people are uptight. I don't blame them. People are uptight. And, the thing about doing live TV is that, my mantra has always been be as available as I can.
Oh, yeah.
And so if they call, I say yes. And, you asked about balancing, I will confess, I've taken a break on a deposition to do a TV hit. And my rationale is this. People take breaks during depositions to do completely wasteful things like, just go get a coffee. So, if I'm taking 3 minutes to do a TV appearance, it's not a big deal. Folks take plenty of breaks. But yeah, sometimes there are conflicts, but I'm lucky in that I don't need to be in an office all day. I have an office, but I don't need to be there. I have, great staff that can run things. And if you're just very vigilant with your calendar, you can really manage both. It can be done, and it's actually not all that hard.
I have to say, so I watched the piece on NBC News Now today, and I was hoping for like a lengthy, in-depth interview, and it was, they had you on. Alex Jones should be worried, and call it a day. So it was very brief.
Yeah, well, that's it's funny. That's the nature of the business, and I'll be really candid with you. It's shows like yours that get me very nervous because my muscle over the past 10 years, I'm really a sprinter. I can only muster up enough interesting stuff for about, a 3-minute hit. And I tell folks who are interested in doing TV that you have about as much time as a limerick. And I don't know I'm sure you folks all know what a limerick is, but it's basically a rhyme.
There once was a man from Nantucket.
Well, not that one. How dare you? It's funny. I don't know any other limericks except that one. So I don't know how to give an example. So I need to learn one that is safe. But yeah, you really only have that much time. So these longer format interviews are the kind of thing that gets someone like me very nervous because my muscle is really to do about 3 minutes on TV. That's about how long a guest is on TV for news.
Well, to be fair, I've heard you on one of my favorite programs is Michael Smerconich's his radio program, and I've heard you on there. It's really impressive. One of the things I was curious about is that your firm has a certain practice and you have certain specialties, but you're clearly so versed in a broad range of legal issues. How do you stay up on all the legal matters necessary to have such informed insights?
Well, a couple things. It's when I started out in the practice of law, I bounced around at a lot of places. I really did a lot of Goldilocks. Do I like this? Is this too big? Is this too small? And so I was lucky enough to be exposed to a lot of different areas of practice. Everything from like patent law, which is an arcane kind of it's totally obscure area of practice, to big civil litigation at a large firm, to criminal defense, which I ended up getting into when I started my own practice, really for no other reason than it was, from a business perspective, it's a form of relatively fast cash flow. Whereas some of your injury or civil cases, you have to wait years for them to yield fruit. So, I've had, when you're a solo practitioner and you're starting out, as I was many years ago in my apartment with like a cardboard box for a desk, you take everything and anything. And so I got very early on, I got, baptized in that I was just thrown into lots of different situations and I had to figure them out. And, I can't say I batted 1,000, but when you have a practice that is small, you take on a lot of different kinds of cases. And so that's how I've gotten exposed. The other reason I think I'm able to is that because I have chosen to take the bar exam in a number of different jurisdictions. And I'll tell you, studying for that dumb test, they just give you you're just in a perpetual state of studying. So I've kind of I still have those bullet points stuck in my head. And I guess finally, I really more of a magic trick because I'm already reading up on all the stories of the day. Sometimes there's some breaking news, but even if there's breaking news from the Supreme Court, I've probably been watching it a little bit. I have an idea, but I'll tell you the hardest thing to do. And the Mueller report was a good example because we went live with that, or a Supreme Court opinion that comes out. all of these opinions and documents are now in the hundreds of pages. And sometimes digesting that on live TV can be pretty scary. But, today you watch that story about the Alex Jones defamation case. And, I'm familiar with defamation cases. I've been involved with them. I'm familiar with, procedurally what's going on, even though I'm not a Texas lawyer. There are similarities enough that I can kind of figure it out. And so I just read up on it. And I just, like anything else I do when I'm doing it on TV, most of the time I'm just trying to muddle through.
Muddling our way through. We've all gotten used to that over the last couple of years. I've become a big fan. I don't know if you've ever listened to Advisory Opinions. It's with David French and Sarah Isgur, but it's one of my favorite resources. I've learned so much about the law and have been able to dig in on specific cases. And SCOTUS blog is very, for non-lawyers like me, just engaged citizens, it's very approachable. It's not beyond just the average intelligent, curious person. Are there certain resources that you might recommend for just regular folks, engaged citizens like me?
I got to tell you, Jeffrey Rosen's Constitution Center podcast, We the People, is fantastic. It can get a little bit in the weeds because what he does is assemble, the geniuses on a particular topic, and they'll not necessarily debate, but present both sides. So he's a fantastic resource. Typically, if I know abortion is going to be coming up, when abortion was coming up, I went back and I think he's got 3 different episodes on abortion. And just to cross train, I'll read up on the briefs, but I'll also listen to what the geniuses have to say. And that is, podcasts are a tremendous resource for me. And, the ones you mentioned are fantastic. I got to tell you, the wonderful thing about podcasts is it's given a voice to all these legal geniuses that were superstars to me, even when I was in law school, that other folks might never have known. But now they get a voice. And I think that's pretty exciting because, some of the folks Jeffrey Rosen has on his podcast are just, the leading minds in the field. And, 20, 30 years ago, those were the kind of folks who would write a treatise and no one would really know who they were, but they were superstars. And it's almost frustrating that no one knew who they were. Now, these are folks who can have a voice and it's really exciting. And it makes my job really, really much easier when I can, with the touch of on my touch screen of my iPhone, access the inner workings of the minds of just the most brilliant legal scholars because they've appeared on podcasts. So I live in an era where it's become so much easier to do legal research, especially considering when I started law school, we were only just beginning online research. You would have to go to the dusty old books and look things up. So it's just an amazing time that not only can I find anything I need online, I can find the filings, but I can even pull out, a podcast and listen to just these brilliant minds who get assembled on Advisory Opinions and Sisters-in-Law and the Constitution Center podcast. It's such an exciting time if you want to learn about the law.
Well, today, TP&R, our podcast, has Danny Cevallos on. So I'm sure Jeffrey Rosen and Sisters-in-Law and David and Sarah from Advisory Opinions are going to be saying, listen to that one episode of Talk Politics and Religion with Danny Cevallos.
They make me nervous. They're too smart.
No. So speaking, you mentioned abortion. We have a lot of cases, like really important cases that are going to have an impact on our society. I don't think I'm being exaggerating when I say that. And so why don't we just dive into that? You mentioned abortion. Obviously, a lot of folks are familiar with Dobbs v. Jackson Women's Health. I'd love for you to start. If you could just tell us, what does that case? What does that decision do, and what does it not do? Because I've heard a lot of folks feel very, very passionately about it. But I think there's a misunderstanding of what that decision actually means. So could you fill us in on that?
Yeah. The top line summary I think that you're asking about is, a lot of folks seem to misunderstand that when Dobbs came out, it did not itself outlaw abortion. In a sense, it effectively did because it returned the issue to the legislative process of the several states. And those states not only can, but have already moved to outlaw abortion. And in fact, what Dobbs does, simply put, is return to the states the choice legislatively to either completely outlaw abortion or allow abortion right up until the moment of birth. But to just kind of give the backdrop to Dobbs, because I think the history is so important. The question becomes, how did we get here? How did we get to the point that we are where Dobbs, where 9 justices decide an issue that seems so important? Well, when you go back, this is really about something called substantive due process. And this is the genesis of the Roe v. Wade and Planned Parenthood v. Casey opinions. Many, many years ago, the idea of a constitutional right was that only really that which was explicitly in the Constitution. It wasn't really until, well, I guess I would say about a century ago, the court toyed with recognizing the implicit right in the Constitution that wasn't explicitly there, such as the right to contract. It flirted with that, and then that went away for a long time until the Warren Court. And during the Warren Court, which was the 60s and 70s, the court began recognizing what was called substantive due process. The idea that beyond just the rights that are explicit in the Constitution are rights that are implicitly there. They glow from the penumbra. And a penumbra is, I believe, something that's I think it's the same as a corona. It's the glowing area around a light. They glow from the rights that exist in there. And the reason that's important is that if the state wants to infringe upon a constitutional right, typically they have to show what's called strict scrutiny. They have to show that the law or the regulation is necessary to achieve a compelling interest. You don't need to memorize that test, because I'll tell you what they told me in the bar exam prep. It means that the state law is always going to be struck down. It's pretty much always going to lose. But if it's not a constitutional right, then the analysis shifts completely. And the state statute will almost certainly survive, because all it needs to show is that it's rationally related to an important state interest. And so the bottom line, again, they taught us in bar exam prep was, well, just conclude that the state law wins. So it's a very big difference between claiming that you have a right to something and having an actual constitutional right. So now we move on. And so everyone speaks very often of, hey, look, there ought to be a right. You should have a right to this. You should have a right to that. But the moment something becomes a constitutional right, it becomes a very important thing in our Constitution, which means that it cannot be taken away. And a lot of folks think, hey, that's a great thing. But at the same time, anytime the court creates rights like that, it is necessarily overpowering the will of the people through their legislators. So that's the controversy, is that it feels good to say, hey, there should be a right to something, and maybe there should be. But when judges create it, then as Justice Scalia was fond of saying, it's a kind of tyranny. And I'm probably not paraphrasing him exactly right, but he would frequently say that, look, when you create rights through 9 unelected justices, whatever those rights are, then you have subverted the legislative process of the states. So that brings us to Roe v. Wade. Roe was one of those recognitions of a penumbral right, a right to privacy that did not explicitly exist in the Constitution, but that was something that did exist there, according to the Warren Court. And later on in Planned Parenthood v. Casey, the court converted that to a kind of liberty interest. It actually evolved a little bit by the time it got to Planned Parenthood v. Casey. But Roe essentially created a trimester framework, but held that there at a certain point, a woman's right to terminate the pregnancy is part of her bundle of rights of privacy. And later on in Planned Parenthood v. Casey, that became the undue burden test, which was harshly criticized. Now, that brings us up to Dobbs. And I even wrote a piece probably 3 years ago, I think maybe when I was back at CNN, saying that, look, actually, now that I think of it, was at NBC. But the point is, I said that I don't think Roe is in any danger. And I got excoriated for that in the recent past. And my belief was, even though the court could conclude that Roe was wrongly decided, there's a second factor. You don't just overturn precedent just because something's wrongly decided. You have to decide whether or not, the court has to decide whether or not there are reliance interests. And in my mind, the reliance interests were too strong because it had been too many years. We've had this rule for a long time, therefore there's reliance. But I was wrong about that, and that the Supreme Court disagreed. They took a very interesting view of reliance, and this is the kind of thing about legal analysis that fascinates me, is that I missed this. But the idea was that you can't have a reliance interest in abortion because it's always something that happens and is prospective. In other words, no one plans for an abortion until they need one. Whereas, for example, if you talk about same-sex marriage, there's a tremendous reliance interest there. And that's why I don't necessarily think that's on the chopping block, although, now I feel silly because I felt the same way about Roe. But, if you invalidated same-sex marriage, there are tremendous reliance interests at stake. There are entire families, couples with kids that would be undone. Whereas the argument, I think, by the conservative justices, you don't have the same kind of reliance with abortion because it wouldn't undo anything that was any pre-existing contract. It just means that going forward, people could not have abortion. So anyway, I mean, the bottom line is that is really what Dobbs was about. And what folks should really think about is that abortion was kind of a side issue. Yeah, I mean, Roe and Planned Parenthood v. Casey, it's very historically significant that they were overturned. But some commentators have said this could mark the end of substantive due process completely. That is, and we even saw that with Justice Clarence Thomas in his opinion. He said that we should reevaluate cases that gave the right to same-sex marriage and some of the other cases that involved substantive due process. So, as fired up as people are about the overturning of Roe and Casey, what I think is the real story is that this may be the death knell of substantive due process. The idea that there may be rights implicit or glowing out of the words of the Constitution that are not explicitly in there in the text.
So I want to dig in on this substantive due process, this concept, because Thomas, as you point out, did bring it up in his concurrence. And he brought up cases involving same-sex marriage, contraception, sexual intimacy by same-sex couples, brought all of these into question. But he didn't bring up Loving versus Virginia. Was that not a substantive due process case?
Yes, it is. And I think a lot of folks noticed that he did not bring up Loving. And yeah, that is, I mean, I don't know why he didn't mention Loving, except that there are arguably civil rights statutes that, candidly, I don't know why Thomas didn't bring up Loving. I've heard folks reportedly criticize him for it. But I mean, I think the takeaway is that anything that is based on substantive due process, like those other cases he mentioned, Griswold v. Connecticut, contraception, all of those are at play. Now, I say that with an asterisk because contraception is not really at play. And here's why. There are no states that are going to, in my mind, move to create a case. And, in other words, to shop around for a case that involves contraception, unless you have another situation where you stage a police raid on a married couple's, home to find them using contraception. In other words, I don't know that there's any great clamor to overturn Griswold v. Connecticut, the contraception case. I don't know that there's any great march on Washington to overturn same-sex marriage. I think there probably are people that would like to see it overturned, but not in the way that Roe v. Wade and Casey were controversial. So I think those are hypothetically possible. It could be, honestly, Thomas was engaging in a form of trolling just to get people whipped up. I mean, I hate to say that. I would hate to think that a Supreme Court justice would do that. But here's the thing: if you're authoring an opinion that is not going to be controlling, in other words, if you're authoring a dissenting opinion, for example, and if you're a minority justice on the Supreme Court and you're authoring an opinion that will really just be read, for that because people find it interesting, not because it has any precedential value, then you have an opportunity to sound off about all the things you're disgruntled about. And I think you've seen that a lot in dissents in the past. And Thomas, in this case, knew that would be nothing more than, even if it was even dicta, it's just really a side comment. And I mean, if getting people fired up was what he wanted to do, mission accomplished, because I have to tell you, everything else in that opinion was kind of predictable. And I say that because there was a leaked opinion that kind of told us everything that was going to be in there. So it was Justice Thomas's comment there that I think got people really, really upset and really fired up. And I got to say, I understand, because to me, the reliance interests are so much greater. If you undo same-sex marriage, then where does that leave families with kids? If you undo contraception, and as a historical note, even the state of Connecticut was looking to overturn that contraception law when Griswold v. Connecticut, when that case began. It is, like many cases, sometimes a manufactured set of facts for the convenience of the court. I'm not saying anyone did anything wrong. I'm just saying that sometimes, look, I don't see another situation where police are kicking down doors looking for married couples using contraception. So I guess anything's possible. But look, I think the real message is that substantive due process, anything that ain't in the Constitution explicitly, is no longer really in it, possibly.
Yeah. Yeah, so many different issues were brought up as we're now questioning whether contraception or sexual intimacy by same-sex couples. I'm now imagining the Texas law, where basically the citizenry is deputized to, and now talk about trolling Governor Newsom out here in California, basically implemented the same mechanism, deputizing folks. Except in Texas, it's about abortion. Out here, it's about guns. So, a citizenry gone wild. But there was something I did want to ask you about. Thomas's concurrence was different from the Kavanaugh and Roberts concurring opinions.
Yeah.
Can you help make that distinction for us? The Roberts one in particular, there were some significant distinctions. Could you help us understand that a little bit better?
Sure. The Roberts opinion, and Roberts signaled this throughout oral argument, that Roberts was looking for a kind of middle ground. During oral argument, he suggested possibly doing away with the viability standard. So what Casey did was it created a viability standard. And it created, a simpler test, which is viability is the ability of the fetus to live outside the womb. I should not have said simpler. I want to go back and amend that, because my point is that it's a very difficult test in that viability is an incredibly elusive concept. So what Roberts was suggesting throughout oral argument is, why don't we instead talk about doing away with viability, and we can keep Roe v. Wade in principle, and then we'll set a new standard, be it, I don't know, a different number of days or months into the pregnancy, a bright line rule instead of this viability standard. By the way, one of the things that's always troubled me about viability is that every single day that technology advances, the definition of viability changes. I mean, technology redefines all kinds of medical concepts. Technology redefines death. I mean, death, I would argue, has a different meaning than it did 100 years ago because of medical advances or advances in medical technology. Life, has a different definition than it did many years ago. Similarly, the idea of when a fetus can live outside the womb has changed dramatically in just the years since Roe and Casey were decided. Casey was a 1990s opinion, but it's changed a lot since then too. So the viability standard was always problematic, as too was the undue burden standard. And Roberts was pushing for that, but the problem is that neither side would bite. Neither side wanted anything to do with that middle ground. Each side wanted all or nothing. They either wanted Roe and Casey to survive completely intact, or they wanted them completely struck down. And so that is the direction that Roberts mostly went. I thought it was a really interesting direction because it's almost consistent with his theme, which has been, he's the institutionalist. He worries about things like how the court is perceived. So, look for him to try and mediate a middle ground. He tried that, and not even the litigants wanted any part of it. The litigants wanted only, all or nothing or nothing else. Interesting.
The other issue that's been raised has to do with precedent. A lot of the hearings, almost every hearing that we've heard for Supreme Court nominees, the term stare decisis is a big theme. So the Roe v. Wade, you mentioned Planned Parenthood v. Casey, you mentioned. So is stare decisis out the window, or is it just on a limited basis?
No, stare decisis still exists. I mean, and this is something that Kavanaugh, this is a big issue for Kavanaugh, which is the idea of when do courts decide to overturn their precedent? Because we have kind of a paradoxical rule in jurisprudence, and it's this. The idea of common law is that we follow the decisions of courts that came before us on the same issues and the same facts. Now, the wiggle room is there ever really the same exact set of facts and the same set of issues in a particular case? But generally speaking, courts follow the decisions of the courts that came before them. That's how they build case law. That's how they build the common law. But what do you do when a case is wrongly decided? I mean, so you have this paradox. You have to follow what the court said before you, especially the Supreme Court. But sometimes the court is wrong. I mean, there are very clear examples in history of when the court was wrong. Plessy v. Ferguson. So what does the Supreme Court do? I mean, especially because, decades, maybe even a century or so later, our society's values change. And, what do you do when you're confronted with Plessy v. Ferguson and you're the Supreme Court? Well, you can overturn precedent sometimes, but it shouldn't be, well, actually, the court, has a test for it. And strangely enough, it's not just the question of whether or not it's wrong, or as Kavanaugh would put it, egregiously wrong. It's additionally, whether or not that decision, people have relied on it. And that's when you're going to take away rights. But the first analysis is whether it's egregiously wrong. Now, there are different views on the court about when to overturn precedent. For example, I believe it was Justice Thomas who takes the view that, look, I mean, when it's a constitutional issue, there should be a very low standard of deference. There should be a very little deference, because otherwise it would mean that the first court to address a constitutional issue gets to decide what that is for all time. And I understand that. I mean, as it is in our appellate courts, when there is an issue of law, the lower court is given much less deference on a strict interpretation of the law. So that approach has some precedent in our jurisprudence. But yes, I mean, stare decisis still very much exists. It is the bedrock principle of how courts decide cases. I mean, we look at the reason that the Dobbs case spent so much time on history was because, and a lot of folks might have said, well, what do we care about the opinions of people from hundreds of years ago who had very retrograde views about things like women and minorities, and I mean, we're going back to almost slave times, and we're looking at what people thought then. And that's I totally understand that perspective, but our jurisprudence is based on precedent. And one of the things Alito spent a lot of time doing in the Dobbs case was deciding whether or not the right to an abortion was firmly rooted in our history and traditions, whether it was something that was so deeply rooted that it was just, a part and parcel of our American experience. And by going through the history, in many, many years of history, he concluded that it was not, that the right to an abortion did. And I have to tell you, as an aside, one of the things I learned, in the last several years was that abortion even existed at the time of the founding. I mean, I would have thought, if you had just asked me off the bat, I would have said, oh, abortion must be a product of, I don't know, the last 60, 70 years. But all I could think about is, my God, what an awful, horrific experience abortions had to be in the 1800s. I mean, can you imagine? This is the era of, you get shot in the arm, bite on this wood while we saw your arm off. I mean, that's the state of medicine at that time. So, Alito, not surprisingly using that analysis, concluded that abortion was not a part of our history and traditions. And in fact, it was largely outlawed in many different ways, 100 or so years ago. And no surprise. I mean, you could not expect an America of 100 plus years ago to have thought about abortion in terms of a right to privacy for women. They wouldn't have done that. I mean, and so again, these are retrograde views, but if the analysis, the test is whether or not it's deeply rooted in our history and traditions, well, abortion was going to be on the chopping block, because that's a pretty tough standard for abortion to satisfy.
So before we move on to arguably an even more consequential case of this last term, I did want to ask you about that Texas law. I alluded to it just a second ago. The Texas law basically deputizes the entire citizenry to sue. I think it's $10,000 to sue a neighbor, somebody that you suspect of being involved in an abortion. Do you think that that's going to stand long term? And if so, I'm just curious, what kinds of cases are going to be presented? What is going to be the injury? I'm just confused about how that actually works. And I'm imagining some kind of Supreme Court case of the future where this law is challenged. Do you think it's going to stand long term?
So when I look at this Texas statute, we were doing a lot of analysis on it probably, it feels like 2-3 months ago. But what was really fascinating to me about this law is that it seems to me, and I've read about the architects of it, it seems to me that some genius, and other people might call it diabolical, whatever the case may be, but it is a diabolically brilliant way around judicial review. And this is what the statute essentially does. It deputizes, it says the local prosecutor is not involved. The police are not involved. The government is not involved. Instead, regular citizens have a cause of action against anyone who provides assistance to an abortion. Now, why do this? Well, because by doing that, they've left nobody to sue. So typically when you want to enjoin a government from doing something, you don't sue the government itself. You sue, for example, the local district attorney to prevent him from prosecuting, using a particular law to prosecute someone. That's how you procedurally stop a state or a government from doing something. So what this Texas statute did was leave nobody to sue, because until someone brings a lawsuit, you don't have a human to sue. And then even when you do, that person might not even have any, it creates kind of a procedural anomaly in that there's no way to stop these lawsuits. Now, people are trying to file suit against the courts and prevent the court clerk from docketing any of these lawsuits, but there's a lot of case law that says that you can't sue courts to prevent lawsuits, or this is not a proper method to challenge a statute. So, here's the thing. My opinion is that this Texas statute has to go down, not because of any reason having anything to do with abortion, but because what's good for the goose is good for the, I think it's gander or gravy. I probably shouldn't have started that saying without knowing how it ends. But the bottom line is that if this is allowed to stand with abortion, then it works for every other right. You could do it with guns. There's nothing to stop someone for creating a cause of action. And yes, I know there's a Second Amendment right and there would be a defense, but who cares? If you created a cause of action that somehow allowed you to sue people for gun ownership, okay, maybe they win, but that person still has to hire a lawyer, file a motion to dismiss. I mean, the mere fact of having to defend a lawsuit is enough of a burden that it would seriously impair gun ownership. But let's take something that isn't a constitutional right. You can imagine a million different things that could be completely eradicated if a state legislature didn't like them, by simply deputizing citizens to sue over it. So, I've looked at this statute and I've said two things to myself, which are, the first one is there's no way procedurally to challenge this. They've created an assault-proof statute. And the second thing I think is they're just going to have to make up a reason, because you just can't have this is an unfair advantage in legislation. I mean, it's using a cheat code in legislation because it creates statutes that can never be challenged. And if they can do it with abortion, they can do it with anything else. It could be something that targets, a right, a liberal issue. Could be anything. So as much as I think this is a really problematic statute, and by the way, you mentioned who it deputizes. It deputizes everybody.
Yeah.
Some of the lawsuits were brought from people outside the state. So how are you going to even get jurisdiction over them it creates a huge mess. Wow. And honestly, I don't know that this is a case where this is a situation where, as brilliant procedurally as this idea is, it's it's a nuclear bomb of of civil procedure. It creates a situation where you can never challenge a statute, and we can't have that. It's gamesmanship, and I think the early opinions that have dealt with it have addressed that. That you found a weakness in the rules, and that's not to be rewarded. That should be shored up and fixed. How they're going to do it, I don't know. But I mean, if I were the emperor, or if I was emperor and justice, I would just declare you cheated. I would just say not fair. It would just say, look, I don't know what else to tell you. I can't justify what I'm doing, but fortunately, I'm not the emperor and I'm not a Supreme Court justice. But that's how I would deal with it. I just don't know that I don't know that there's a fix other than just declaring foul and not really explaining why.
It's interesting as you were describing that statute. It strikes me that there were a couple of cases in this last cycle, and one in particular that's coming up in the next, that challenge the balance of power between the three equal branches, between legislative, executive, and judicial. So I don't see what remedy the other branches. To your point, I don't see how this can be remedied by the other branches. It's a really interesting case. So I am curious to see how it plays out over the next couple of years. Like I mentioned, I don't know if you're up to speed on everything Governor Newsom's doing out here, but he signed it into California law, I think last Wednesday or Thursday. I was just joking with a couple of my friends that are gun enthusiasts. Hey, I don't know if you know, but I could sue you now for 10 grand. So,
yeah, right.
But one I already mentioned it, but one I did want to ask you about, arguably even more consequential than Dobbs, as passionate as obviously as heated of an issue as Dobbs dealt with. West Virginia versus EPA struck me as very consequential. Could you give us the summary on what it does and why it's significant?
Yeah, what's interesting, I think a lot of the really important Supreme Court cases often go unnoticed, and I don't blame folks for this, but sometimes they're just a little too complicated. They're a little too in the weeds, but they can quietly affect more of our lives than arguably some of the marquee cases that grab a lot of attention. And I think the West Virginia case was one of them, and it really is part of a body of regulatory issues. One of the things to go back to a civics lesson, as my grandfather used to say, two amoeba met in a primordial ooze, because I'm going to take you way back to the beginning, which is that, the way our government works. I often, teach a law class at the School of Nursing in Philadelphia, Drexel University. And one of the things I often ask my students is, what part of the government makes law? And almost everybody who's had civics will say, well, the legislative branch does. And that's true. But in fact, all three branches create law. The judiciary creates law through interpreting cases. And those interpretations become part of the common law, the case law that we talked about earlier. So judges can create law. In addition, the executive branch creates law. There are many ways that the president can create law through an executive order. But one of the more controversial ways that most folks don't really pay a lot of attention to is through regulatory agencies. In other words, Congress passes a statute, that's the legislative branch, and that statute might say, okay, this agency, the EPA, thou shalt, enforce this particular law. Well, laws are often only a few lines, and they don't really flesh out everything that has to be done to enforce or put into play that law. And so the agencies, which are part of the executive branch, then get to use their own considerable authority to interpret what that federal statute says they can and can't do. This has been a big issue of Justice Gorsuch's. He called the regulatory agencies a kind of behemoth. And I'm probably poorly paraphrasing what he did, but how he put it. But what has happened over many years is that these regulatory agencies do engage in a process called rulemaking. And the Code of Federal Regulations is an entire, volumes upon volumes of different rules. And those rules have the force of law. I've defended criminal cases in which these rules are, part and parcel of the prosecution, even though no one ever voted on them, that no elected official ever passed them. They were created entirely in the executive branch. So going back to West Virginia, the issue was, to what degree can the EPA regulate activity? Now, in this case, it was activity off site of a power plant, I believe. And it would be missing the point to just say, hey, the EPA does an important job and therefore they should be allowed to regulate anywhere and everywhere. Well, that's an understandable sentiment. And I think reasonable minds can conclude that. But folks, especially conservatives, would take the view that, well, no, the EPA can only exercise the power that it has under federal statute. And if it isn't in that federal statute, or if it's contrary to that federal statute, then they don't have that power, because that's not what Congress said they could do. And anything else is a form of tyranny, the argument goes. Because if it's not in a federal statute, that's what the people said. The people elected representatives. Those representatives created a law, and that law was voted on by the representatives. But if the EPA, creates law on their own, that's an executive branch official who was never voted on, never elected, nothing. And when judges do it, as we talked about before, that is certainly not part of the democratic process. So, really, the issue in the West Virginia case came down to the analysis of whether or not the power the EPA sought to exert was granted to it under federal law. And it concluded that it was not.
I've heard Sarah Isgur make the assessment that there were several cases where the Supreme Court was basically telling Congress, hey, do your job. So I'm curious if you think there is anything the legislative branch can do about at the federal level, like some version of the Build Back Better plan, or does this case make that kind of legislation unlawful or unenforceable?
Yeah, it's interesting to go back to abortion for a minute. I was on, quite a bit, like many folks who do what I do, during the Dobbs case. And one of the things I saw time and time again, you still see it, is on the news, there are a lot of polls cited where it'll say something like, 65% of Americans say that that there should be a right to an abortion. And I always think, that is so frustrating for those folks, because the whole point of abortion, of the right to an abortion, is that it has been returned to the people, arguably. So if it's true that there's 60+% of Americans who believe abortion should be a constitutional right, well, then something's going wrong. That means that it's not being expressed through, because, by the way, voting is a kind of polling. When you vote on issues or representatives, if it's true that 60 to 70% of Americans think that abortion should be a constitutional right, why aren't they voting? I mean, that it's such a, I don't know the right word for it. Maybe it's a paradox, but maybe it's a really sad irony, because it's I would say, if I were being glib, stop taking online polls and start voting, if that's really what, if that's really the state of people's opinions. Because this is the kind of thing, it frustrates me when I hear Congress people rail against Dobbs, because Congress could probably do something about this, or it could have in the past, maybe through a constitutional amendment. Although I should add that they may not be able to use now this may be getting too into the weeds, but really what the Dobbs court said is that the due process clause can no longer, support a right to an abortion. There are Supreme Court cases that suggest that now that the Supreme Court has said that, Congress cannot come back and say, oh, no, we say that it does support the right to an abortion. They might be able to do it under the Commerce Clause power, but Congress has a lot of power here. And so I understand folks' frustration, because, including the Supreme Court's, because I think if you were to ask some of the conservative members of the court, they would say, we would rather Congress handle this. We don't want to be in the business of making law. I think that's the way the conservative justices would respond, is that, the whole point of their originalist approach is that they're not supposed to be making law. That's supposed to be left to Congress. So I think probably you might find that some justices on the court are frustrated with Congress.
Yeah, you bring up a really interesting point, that a lot of folks I go to church with have been single issue voters. They can never bring themselves to vote for anybody with a D before their name on one issue and one issue alone. A lot of folks I've gone to church with have fully embraced and fully support an individual like Donald Trump because they say, well, the judges, and that alone. So to your point, it's almost like the sleeping giant has been awakened. There are a lot of folks who are going to be single issue voters because now abortion wasn't on the table. Abortion was only a single issue was only a single issue for voters on one side of the issue. But now we're getting into politics, and that's not why I brought you in. I do want to ask you though about the legal cases stemming from the January 6th insurrection. I can't even keep count anymore how many cases the Department of Justice is already pursuing and where they all stand. Do you have any updates?
Well, let me start with this. When you talk about January 6th, there's a huge spectrum of people facing potential and actual criminal charges. You start with the easy ones, and that's in a way what Merrick Garland and the Department of Justice and the local U.S. the U.S. Attorney's Office for the District of Columbia, what they've done is actually DOJ Rulebook 101, which is start small, get all the easy layups, the low-hanging fruit, the nudniks who actually entered the Capitol and carried away podiums or sat at Nancy Pelosi's desk. Get those guys.
So nudniks, that's an advanced legal doctrine.
Yes. Yes. Yeah, that is a legal term of art. Get those guys. Yeah. They are remarkably easy. And I guess, so those are the easiest people to convict, to turn, if they know anything about the organizers or Trump. And you've seen little by little, but by the way, which they're not likely to know a whole lot other than they were big fans of his and they felt like he was speaking to them. But then from there, you've seen DOJ move up a little bit to the organizers. And now, presumably, we can only assume they're poking around at, folks in Trump's inner circle and Trump himself. Although we don't know for sure because the DOJ doesn't give us a heads up as to what they're doing. That's why the DOJ is so devastatingly effective. So you start with, the folks that were actually entering the Capitol. Those are relatively easy prosecutions. The government has lost, I think, a couple, but not the egregious ones. They've lost, I think, a couple bench trials. But I mean, from there, the organizers, you do have seditious conspiracy charges. And I think, those are difficult cases to make, but the DOJ believes they can prove them beyond a reasonable doubt. I think it's tactically very clever because, charging seditious conspiracy opens up a whole world of additional stepping stones for the DOJ. But now we get to the January 6th committee themselves, and I've been covering each of the hearings. We watched live on and commented on for NBC. And the question, I hear the question a lot: what potential charges are there for Trump and the people in his circle? Whether it be the lawyers in DOJ who were doing his bidding, Jeffrey Clark, some of the others, Rudy Giuliani. So you hear a few statutes thrown around. Most commonly, you hear conspiracy to defraud the United States, conspiracy to obstruct an official proceeding. And those are the two big ones. And they're pretty much defined as you might imagine. In other words, was Trump conspiring to obstruct an official proceeding, meaning Congress counting the votes, and Vice President Pence opening the envelope, essentially, and having the votes counted? And then we can talk a little about Georgia, because I think Georgia is a very important side story here. But, the committee is presenting a case that really is not geared towards making out a criminal case. They've certainly made Donald Trump look really, really bad. But I don't know that they have adduced new evidence that would create criminal liability. Now, I want to just say here that if you look at the statutes for, let's say, a conspiracy obstructing an official proceeding, I will grant you that you could go through the elements of that crime and make a straight-faced argument that Trump has done all of those things. And a lot of folks have gone on TV and said that, and a lot of folks feel that way. And I totally understand. But this is a one-sided affair. The January 6th committee is not an adversarial hearing. It's not a debate. It is like a grand jury proceeding. It is completely one-sided. There isn't even a defense attorney in the room.
I want to push back on that. I actually heard you and Michael Smerconish talking about that. And I would like to push back on that a little bit. For one, sure. Representative John Katko presented an option for how these hearings could go, where it would have been much more equally balanced. And then, but that was rejected out of hand. Whether you could say it was McConnell or McCarthy threw a wrench in it, one way or the other, that's a Republican representative presented an option for this in the first place. And then even with the committee as it's structured now, McCarthy chose to be cynical up front by putting members of Congress on the committee, by submitting potential Republican members of Congress on the committee that he knew full well were likely, you could make an argument and intelligent observers could surmise that were complicit in the events of January 6th. So
sure.
There were plenty of steps along the way where there could have been more equal representation on that committee. And as far as having equal representation or what's being refuted in terms of, we have plenty of refutation in real time from Donald Trump himself, as sure. well as, so it's not being presented obviously on the committee, but there's plenty of pushback, to the extent that in real time, the entire conservative media complex is getting exactly what their talking points are and is the voice of the other side per se. I take issue with that objection because there were plenty of opportunities to have a more equally represented committee in the first place. And there's no secret about what the response is all along the way in real time.
Right. I agree with you that the opportunities were there for this to be a more even-handed presentation. But whatever those choices that were made, we're left with what the American public have seen. Because I think maybe a lot of members of the American viewing public maybe aren't aware that there were these opportunities. So let's just look at what they see when they tune in to watch their Congress people put on this presentation. And the presentation itself, and you could blame the Republicans for it, has been one-sided. So strictly from a criminal prosecution standpoint, to take only what they've presented and say, oh, this is obstruction of an official proceeding, really is, and this goes to the core of why Donald Trump hasn't been charged yet, because there's more to the story. And any federal prosecutor worth their salt, who usually has a 95+ conviction rate, does not want to take on a case that they might lose. And what we're not going to hear about during the committee hearings are the potential defenses, the First Amendment defenses, the lack of actual knowledge defenses, which they've tried to short circuit. Representative Cheney has tried to short circuit that by saying, listen, their ignorance only goes so far. He can't claim that he had no idea what was going on at all. At some point, believing you won the election in the face of many, many smart people telling you that you didn't becomes unreasonable. But at the end of the day, the other thing that a prosecutor has to consider is something that I don't hear folks talking a lot about, which is this. At the core of this case is about whether or not what Donald Trump did in believing that he won an election. It's not about a straightforward crime like robbing a bank, which everybody knows is illegal. But I would venture a guess that if you ask most folks what happens in elections, they might say, look, each side does whatever they can to win. It's a bare knuckle situation, politics and elections. Everybody does their own dirty tricks. I don't know what they would say, but I think folks would at least admit that it's a hazy, shadowy world, the entire election process. Not that I'm not the actual casting ballots. I'm saying, what each side does to try and win. I'm not saying in any way that there was, a problem with the election process, more that people do whatever they can to win. So Donald Trump, believing that he may have won the election becomes a core issue. And a prosecutor has to think about the makeup of a jury. I mean, is there anyone on that jury that thinks that people engage in dirty tricks during elections? If so, that's somebody that might at least hold out or acquit. Is there anyone in there that just thinks election law is too complicated? I mean, you might lose that juror, and that juror might, hold out or vote to acquit. Is there a viable First Amendment defense? I'm not so sure. I mean, elections implicate the First Amendment, and the First Amendment is anytime you're criminalizing speech, which is really what all this is. You don't have a situation where anyone, held up a gun or attacked anyone physically. These are words that we're trying to criminalize. And any time you criminalize words, there are so many different defenses. Sometimes context can be a defense. Sometimes the First Amendment can be a defense. Sometimes political speech can be a defense. Sometimes intent can be a defense. So I think very reasonable minds can look at what the January 6th committee has presented so far and say that clearly fits within a federal criminal statute, like obstruction of an official proceeding. But I also think equally reasonable minds can conclude that this is a case that the government wouldn't be able to prove beyond a reasonable doubt. And I think they're both right. And I don't think I'm hedging my bets when I say that. I do think they're both right.
So is there a calculation? You mentioned this, but I want to ask the questions head on. Is there a calculation on the part of the DOJ? They have to be 90% certain, 99% certain of conviction if they were to bring a case against a former president of the United States.
Yeah, the principles of federal prosecution say that you shouldn't bring a case. You can indict someone if you just have probable cause. That's the standard at a grand jury. But the principles of federal prosecution say that is not the standard for deciding to bring a prosecution. You must believe you can prove your case beyond a reasonable doubt, considering all the defenses and everything else. And I believe that someone like Merrick Garland is taking that rule very, very seriously. And I guess it's almost like a cheating piece of evidence of that. But I'll tell you, the part of the reason I think that they're taking that very seriously is that they haven't charged him yet. It's been a year and a half since January 6th. And I always assume that whatever the little January 6th committee has with their, interns or whatever they have, I think they would even agree, pales in comparison to the investigative tools that the Department of Justice has.
Yeah.
I mean, the January 6th committee can't even flip a witness. They can't even go to someone and say, hey, if you cooperate with us, we'll give you, substantial assistance and we'll reduce your sentence. And the January 6th committee can't do that. The DOJ can. The DOJ has secret grand juries. Rule 6E, they can't talk about, everything that happens in a grand jury is totally secretive. The January 6th committee doesn't have that. So, I would be astonished. And I've said this on air that I would be absolutely nonplussed if the DOJ doesn't have twice as much as the January 6th committee. And given all that they have, there have been no charges yet. And we're a year and a half, more than a year and a half out from January 6th. And I understand collecting all the evidence, but, statutes of limitations are running. And, if they're still waiting for some blockbuster piece of evidence, that probability seems to diminish, as we get further and further away from January 6th, unless there's some new treasure trove out there that we don't know about. But, DOJ, if they had the goods, they would have charged by now.
Oh, that's interesting. So the potential defenses that you've mentioned, do the same potential defenses apply to the Georgia case?
No, and that's why I think the Georgia case is the biggest threat to Donald Trump. And it doesn't necessarily have to do with the strength of the case, although I'm really, really surprised. And maybe it's, again, the sensational way Trump said it, but there's been so much focus on this. I need you to find me the 11,780 votes, right?
Yeah.
Everyone's heard that clip or seen it in text on their screen of Donald Trump telling Brad Raffensperger, the Secretary of State of Georgia, in a recorded phone call, I need you to find me 11,000 votes. I found that to be a very defensible statement. I mean, I think you could interpret that, again, anytime you criminalize words, you have to consider all kinds of things, including context. And, was he expressing hope? Hey, I just need, this is what I need. I need these votes, darn it. Or was he saying, you better go find me these votes? I don't know. But what's really interesting is in the next breath almost, he says something to the effect of, and I'm paraphrasing, what you and your lawyer are doing, and again, I'm paraphrasing because I can't remember the exact quote, but it's pretty bad in my mind. He essentially suggests that Raffensperger and his lawyer could be committing federal crimes. And that's gone completely under the radar compared to the find me the votes.
Right.
I think that is very problematic. If the chief executive officer, the chief law enforcement officer for the United States is suggesting that someone's committing a federal crime, unless they are complicit, there could be something there for sure. But here's the real reason, the substance aside, the real reason that that case poses the biggest threat is more rooted in principles of federalism. In other words, someone like Merrick Garland has a lot of concern about the institution and whether or not the DOJ, which is part of the executive branch, should be charging a former president, the head of the executive branch. An elected district attorney in the state of Georgia has no such concerns. I would even argue that an elected DA in some county could possibly have visions of sugar plums, dreams of the greatest trophy ever, right? I mean, I'm not saying that's Fannie Willis at all, but I'm saying that could be any DA anywhere.
Right.
And that is, by the way, it goes to the core of that tenuous balance between the states and the federal government. Whatever compuncture, whatever misgivings Merrick Garland would have about charging a former president, I promise you a local DA does not. You might even say they would have an incentive to go after the feds, right? I mean, if it is almost federalism at work to say that Trump faces a bigger threat from a state prosecutor than a federal prosecutor, because the DOJ doesn't really make decisions. Even Merrick Garland doesn't make decisions by himself. He makes it as an institution. An elected DA, on the other hand, really is the king of his or her law enforcement agency, and they can go make a name for themselves if they want to. So that's why I think the Georgia case presents the biggest threat to Donald Trump.
Interesting stuff. Well, my dog just indicated that she is thoroughly unimpressed with all of our, she's not concerned at all about democracy itself. So
good for her.
Yeah, and I'm sure you have kids that would probably say the same. So I won't make you prognosticate on Moore versus Harper, but I would like to have you back after next term because independent state legislature, this is a doctrine that it'll be interesting. I was intrigued by the fact that they took the case, but correct me if I'm wrong, but that only requires 4 of the justices I forget how the process goes, but for the justices to say, yes, we want to hear that case. So it'll be interesting to see, to hear the case and then to see how it's decided. My own feeling, and this is just completely amateur, I'm not a lawyer, I'm not a constitutional historian, but based on what we saw in November and December of 2020, I'm not as concerned about that case as some of my other friends are. What we saw in Kelly versus Pennsylvania, Republican Party of Pennsylvania versus, I don't even know how to say it, DeGraffenreid, dismissed. We learned about the laches doctrine. We learned all of these things, but it indicates there are currently justices that at the very least would defer to a state Supreme Court that would not upset. Again, we're looking at the balance of power that would not say that a state legislature can act completely independently in a way, like an authoritarian way. But that's just my completely amateur prognostication about how that case is going to go. I won't force you to answer anything about that because it's not. We haven't heard the case yet, but I'll give you the floor if you do want to make any comments about that.
Oh no, I'll save that for the next visit.
Okay. Yeah. And I'm afraid there are so many other cases to visit, the religious liberty cases, Kennedy versus Bremerton School District, Carson versus Macon. But but I want to give you the opportunity before we start to wrap up. Number one, tell me about Why Don't We Know?
Oh, Why Don't We Know is my wife's podcast with my wife, Sara Ganim, is a Pulitzer Prize winning reporter when she was and we met at CNN, actually. She has a podcast entering its second season with the University of Florida, and it is about freedom of information requests, what the government doesn't want us to know, and what we don't find out unless we really, really try to pull it out of the government, kicking and screaming.
And I'm assuming it's on all major podcast apps.
Oh, yeah. Yep. Sure is.
Why Don't We Know? So look it up. It sounds fascinating. I'll definitely be looking it up now. My second to last question is, do you have any questions for me? Yeah.
How'd I do?
I think you did great, man. It's really fascinating to me because, again, your depth of knowledge, the nuance of understanding of each of these cases is really impressive. And with like I said before, with two little kids and running a law firm, it's really impressive how in depth your insights go. So I really appreciate that. And I think a lot of my listeners are going to be edified for the insights that you shared. So you did great.
Well, thank you very much. And to your point about the two little kids, whatever I know about Supreme Court, I know far more about Moana and Encanto and all the Disney movies now. That's my life.
That's going to be your life for like the next 10, 15 years. Yeah. My kids are 21, 19, and 17. So now maybe we'll get a Marvel thing here and there, but that was our world for the better part of 10, 15 years. So enjoy it. Enjoy the ride. It's a fun one.
Thank you so much for having me.
Yeah, you bet. And the last question is, how can we find you online so we can, follow all of your great analysis?
Thank you. Cevallos Law, Cevallos Law on both Twitter and Instagram. And of course, check out MSNBC, NBC, NBC News Now, and even CNBC. I do Shep Smith's show from time to time in the evenings at 7 p.m.
By the way, you did really terrific when you were filling in for Michael Smerconish. So,
oh wow,
yeah, maybe we can recruit you to do the Danny Cevallos show at some point. But that's for another conversation. So I really appreciate you coming on, and this was a real treat for me. I'm fascinated by this stuff, and I'm just really appreciative of all that you shared with us. So let's not make it the last time. I owe you a nice, I don't know, if we go back, maybe we'll meet in Philly, and I owe you a nice cheesesteak or something like that.
Sounds great. I look forward to it. Thank you so much for having me.
You bet. And as always, if you dig what we're doing here, please hit that subscribe button, leave a review and comments wherever you get your podcasts, and tell a friend about talking politics and religion without killing each other. We're easier to recommend than ever. It's politicsandreligion.us. It's politicsandreligion.us. Now go talk some politics and religion with gentleness and respect, and have a great week. Thank you for joining us today. If you dig what we're doing here, it is super easy to follow us. You can go to our site, politicsandreligion.us. That's with the and spelled out, A-N-D. Politicsandreligion.us. And we're on all the socials at TP and R Pod. TP and R Pod for Talking Politics and Religion Pod. And here's a big way you can support us: by becoming one of our patrons. You can even become a producer or executive producer of our program and have a lot more say in who we bring on, the kinds of questions we explore, or just help us keep the lights on. But mostly, we really appreciate you giving us a listen. So for the whole team here at Talking Politics and Religion Without Killing Each Other, thanks for hanging out with us. We'll be back in a few days to do our little part in Tikkun Olam.